We'll go back in record.
State of Wisconsin versus Theodore Edgecomb, 20 CF 3535, appearances.
Great Huber for the state.
Speak aloud on behalf of Theodore Edgecomb.
Bobby Lamar, on behalf of Theodore Edgecomb.
All right, it's 1:20. I'm going to bring the jury back in. The defendant's on the stand. We'll continue with cross-examination. Everybody.
Unless the state's not going to try to introduce this in its cross, but there was one issue that has to be taken up outside their presence.
And what is that?
That's the assertion by the defense as to what the defendant's testimony would be in a prior motion.
Right, everybody use the microphones. I'll hear from the state.
Well, Your Honor, in a prior motion filed by Mr. Ahmad, he informed this court that, and these are the words in his motion, Mr. Edgecomb will testify at trial that given the nighttime hours and that it was dark outside, he saw the victim reach for his pockets before he shot him once. He further writes, while he did not see the knife as it was in the victim's pocket, he had reasonable belief that the victim was armed. The defendant's testimony is contrary to that assertion by the defense. The defendant is not stating that he shot because he saw the victim reaching for his pockets. In fact, he's actually saying he didn't even mean to shoot. Also, the assertion there is that they never saw the knife because it was in the pocket appears to be contrary to what the defense is attempting to insinuate. The case on this, Your Honor, is State v. Cardenas, that's C-A-R-D-E-N-A-S, Hernandez, H-E-R-N-A-N-D-E-Z. That's 219 West 2nd, 516 at 1998. In that case, the Court of Appeals adopted the test developed by the Second Circuit in U.S. v. McKeon, that's M-C capital K-E-O-N, at 738 F. 2nd 26, a Second Circuit case from 1984. In that case, the McKeon developed a three-portion test to determine whether or not an assertion by an attorney counts as, and this would be under Wisconsin statute section 908.01 sub 3, which is a statement offered against a party, and the big one is sub 4, a statement by the party's agent or servant concerning a matter within the scope of the agent's or servant's agency or employment made during the existence of the relationship. Or, and this is number 3, a statement made by a person authorized by the party to make a statement concerning the subject. The three-part statement or three-part test that McKeon ends up developing in this case, and that is applied in Cardenas, is, and just let me find it real quick. Apologize. It is on paragraph 18 of the Cardenas-Hernandez decision. First, the circuit court must be satisfied that the prior statement is an assertion of fact that is inconsistent with the assertion at later trial. The inconsistency in the statements must be clear and of a quality which obviates any need for the trier of fact to explore other events at the prior trial or other assertion. Second, the circuit court must determine that the statements of counsel are the equivalent of testimonial statements by the defendant. There must be something beyond the attorney-client relationship to show participation by the defendant. Third, the trial court must, in a hearing outside the jury, determine by preponderance of the evidence that the inference the prosecution seeks to draw from the inconsistency is a fair one and that an innocent explanation does not exist. If the opposing inferences are of equal weight or the preponderance of the evidence favors the innocent explanation, I shouldn't be allowed to use it. So when we apply that three-portion to this, defense counsel, Mr. Ahmad, clearly stated that the defendant would testify that he shot because he saw the victim reaching for his pockets. That's not what he just testified to.
Right, it's an argument made by the defense attorneys in a motion that was filed months and months ago that the jury doesn't know anything about, and I'd rather not invite an appellate issue. You're guaranteeing an appellate issue. in this situation. You have plenty to cross-examine this witness on. He made all kinds of what are arguably inconsistent statements. He testified to things that are not consistent, potentially, with the defense opening statement. He said, to the surprise, I think, of potentially some, that all of a sudden the gun went off. Never once has the defense indicated that, ever. But that's what the testimony was. So why go down this path?
Your Honor, here's the reason why the state's asking me to go down this path. We have the defense counsel stating to the court and asking the court to make a decision and asserting what the defendant is going to testify. It would have been different had they argued it any other way. Defense counsel wrote in there, the defendant will testify.
Yes. Go ahead.
Judge, so looking at the second factor, it says, sorry about that. Yes, looking at the second factor, it says it has to be something beyond attorney-client relationship that shows the participation of the defendant. And the case they're relying on, it was an opening statement by counsel, which you would assume counsel would prepare with his client for that, and he's representing what the client will testify to at the opening. This was a bond motion. I don't even think Mr. Edgecomb saw this. This was just my review of the evidence. I'm talking prior to it being submitted, okay?
The defense counsel wrote, the defendant will testify. If he's saying,
Hang on. When?
Judge, this was filed this summer, many months ago, and
And the state knows, I mean, the defendant's testifying. He's testifying hopefully, honestly, and truthfully. He was sworn to tell the truth. Everybody knows that, you know, it's a live event. Hopefully, the defendant's testifying truthfully. But the testimony that comes out rarely, if ever, can be predicted word for word, and you're going to have plenty of time and plenty of things to cross-examine him on. I'm denying that request. I'm sustaining the defense objection. It's arguably attorney-client privilege. It was just, in my view, hyperbole in emotion. It was filed 6 months ago or 3 months ago. You're opening up a huge can of worms in front of the jury. It has the potential to confuse the jury. I'm not holding the defense accountable for something they argued rightly or wrongly in emotion that I denied, by the way, 3 to 6 months ago. So I'm sustaining the defense objection. Let's bring the jury in. The state can start their cross.